Hello, good citizens. My name is Dan, and welcome to Part 6 of the Victoria Crown Prosecutors Lies and Crime series. So as you heard in Part 4 and 5, Lorne T. Phipps was successful in fooling the bail judge by fabricating evidence and lying in order to intentionally mislead this judge. Lorne did such a flawless job in fabricating evidence that the judge has now detained me until this matter has concluded. What's it going to be, 6 months? A year? Am I going to have a home after this? A job? A life? Is my life a game here? Yeah, I get it. It's retaliation. See, when there's no accountability, they know what they can get away with. That's what you're seeing here. So the following Wednesday, I am back in court before Judge Rogers for the second day of the assault trial. Noticeably, I'm now in leg shackles and prison fatigues. Ron Kirkwood and Greg Haronowich take the stand. When I'm done torturing these two goofs in cross-examination, I had some things I wanted to square away with Judge Rogers. First off, I wanted to ask for a no evidence motion. Apparently, some of the motions in our justice system are so futile, it's not worth wasting time over them. I'm also adding this into the video series because it's come up that I'm wrong about Lorne T. Phipps, Paul Cheeseman, and Melissa Murray fabricating evidence because they're not submitting exhibits that could be fabricated. Well, listen to what Judge Rogers classifies as evidence in my no evidence motion. Here's Judge Rogers to explain more. What I'd like to do is reserve my right to call evidence, and at this time, make a no evidence motion.
Okay, yes, so I'm thinking that unless it's 3 minutes or less, we probably should do that at 2 o'clock. I assume it's going to take you more than 3 minutes?
It will take more than 3 minutes, Your Honor.
Do you have anything else you want to say about that?
If you'd like, I can go into...
Okay, well, let me just give you a little bit of information.
Sure.
And then I'll hear what you have to say. So a no evidence motion is certainly something that's available to you, and it's certainly fine too. It means you don't have to yet make a decision about whether you're going to call evidence. But in order for a no evidence motion to succeed, there has to be no evidence on an essential element of the offense. In considering a no evidence motion, I am not allowed to weigh the evidence in any way. All I have to do is consider whether there is some evidence. So a witness saying us, for instance, Mr. Pooh did, quote, Dan punched me in the jaw, unquote, is all that I would need to find that there was evidence of an assault. All right? There are other elements to the offense: the time, date, place, and jurisdiction. But as far as I can recall, and from a quick review of my notes over the lunch break, there is some evidence of all of those elements as well. And so I'm happy to hear you, but it's a very difficult motion to succeed on because the standard is very low. It's just some evidence, and I don't weigh evidence at this point. I don't consider if a witness is credible. If a witness says it, that's some evidence.
Okay, I won't waste the court's time, and I'm prepared to move forward.
Okay, and just for the record, I will say that I did, because I knew that was your intention. I did consider it, and I do find there is some evidence of each of the elements of the offense.
Okay, thank you. Well, that was futile. The next thing is that I want to feel the irony of being in leg shackles and prison fatigues in front of the judge and prosecutor that know full well that Mr. Pooh made it clear that he no longer lived at Ding Ding O Ding Uphill Avenue. So I wanted to ask Judge Rogers a question. Did I mention the irony? Oh yes, I did. Okay, good. Here's that question. I do have one question, Your Honor, and I apologize if it's inappropriate. How many times is it acceptable for a Crown's witnesses to lie under oath?
So, it's not that it's an inappropriate question, Dan, but the issues of credibility are very much before me in this trial, and I'm not yet at the position where I'm going to make those findings, so you'll be able to make submissions to me at the end of the day if you say the witnesses are lying, and I will consider those submissions. But at this point, I haven't made any determination that anyone's lied, all right? I suspect that some people suggest you'd lied. I suspect you'll suggest the Crown's witness lied. It's clear that both versions of events can't be true, but at this point that's not a determination I'm prepared to make, nor would it be appropriate to make until I heard the entirety of the evidence.
I apologize. I wasn't asking specifically. It's just a general question.
It's not a general question that I can answer.
Oh, the irony. So it's now come to the part in the trial where I take the stand and I tell my side of the story, and then I'm cross-examined by Paul Cheeseman. During cross-examination, Paul Cheeseman whittled away and whittled away and whittled away and eventually suggested to me that I did assault Mr. Pooh. And I replied to him that I suggested to him that he was full of shit. Don't ever try that in court. And after a almost full day in court, there were still witnesses to call. So, back to prison I went, as I now had another week until this trial went into its third day. But now I got to figure out what the hell am I going to do about these new charges? Well, I'm going to have to hire a lawyer. So after a few days in prison, I met my lawyer, Jordan Watt. After speaking with Mr. Watt a few times, he offered me the opportunity to plead guilty in a plea bargain. Basically, if I plead guilty, I'm only pleading guilty to the breaching of the bail conditions, and they'll drop the 2 indictable offenses, which are really serious charges. And I'll be released that day. I can go back to work and not completely lose my life over this. Or I could plead not guilty. They're going to stick with the 2 indictable offenses, and I'll remain in prison for, who knows, 6 months, a year, and I'll have to pay a lawyer probably around $30,000 to run this trial in Supreme Court. And even if it does go to trial, you've seen what happens when prosecutors mislead judges. What are the chances I'd be found not guilty? It's friggin' scary. So the following Wednesday, the assault trial continued on its 3rd day. I called my witnesses. Shortly after, Judge Rogers made a ruling, and I was acquitted. I was found not guilty of the assault charge on Mr. Pooh. Immediately after the conclusion of the assault trial, the arraignment hearing for the 3 serious charges was now starting. So what am I going to do? How am I going to plead? Am I going to stay in prison? Am I going to fight prosecutors that fabricate evidence and mislead judges in Supreme Court? And to be honest, my lawyer didn't really have a lot of faith in my story. To be honest, he wasn't really buying it. And this now being my 2nd week in custody, I've now spent 2 weeks in prison. I was pretty friggin' terrified. So I made the decision, ultimately, to plead guilty to the charge that I could not have committed, and it's even on the court record. If I chose to plead not guilty, my life would have literally been ruined. You can see, I really had no choice. Now, one thing I asked my lawyer, Mr. Watt, was, can I get something on the record about being forced to plead guilty to this? He said that I could do that, potentially, but that may make a situation where Judge Rogers would actually reject my guilty plea and enter in a plea of not guilty for me. And then I'd be going back to prison, and I'd stay there for 6 months to a year, and I'd have to fight this in Supreme Court. So I decided to just keep my mouth shut and let Mr. Watt do the talking for me. So here is the arraignment hearing and the sentencing. And as per usual, I am going to pause this periodically to do some commentary and narrative.
Thank you. I have instructions to waive putting of the election to Dan, elects provincial court judge, and with respect to this information, waive reading of it and enter a guilty plea to count 1.
All right.
Yes, Your Honor. So the circumstances of this offense, this happened August 2016. Mr. Pooh, who's the witness in the previous case, his wife, Mrs. Pooh, was there at the residence leaving the underground parkade. She was in the underground parkade, which is located at Ding Ding O Ding Uphill Avenue.
Okay, so Crown Prosecutor Paul Jeffrey Cheeseman just put it before the court that Mrs. Pooh lives at Ding Ding O Ding Uphill Avenue. How can he seriously go before the court with this, knowing full well that Mr. Pooh made it clear in the first day of the assault trial back in Part 2 that he no longer lives there? And at this point, does this judge, Judge Rogers, have any honor? Will she stand up and put a stop to this illegal proceeding? Or will she allow it to continue?
She was in the underground parkade with her children. She noticed a male up against the parkade gate filming her and her children. She said, "Excuse me," with no response from the male, but she realized that the male matched a description given by her husband of Dan and Mr. Pooh, of course, had advised her that he'd been in court the previous day testifying, being cross-examined by Dan. At that point, Miss Pooh got in her car with her children, locked the door.
Well, yeah, you better lock the door. There's a guy here about to lose his temper and take a picture of the building that you used to live in.
Called her husband to confirm it was the same male. While Miss Pooh was on the phone, the male left and walked up the ramp, at which point Mr. Pooh saw him walking up the ramp, was able to identify him as Dan.
How can Mr. Pooh see me and identify me from within the building that he no longer lives in? Notice the judge, Judge Rogers, hasn't stepped in yet?
That is the nature of the breach, Your Honor. They then subsequently called police, or they called Miss Pooh call 911. She was advised to go to the police, so they went to the police department at 12:05, so just afternoon they arrived and reported this. The police attended. According to the 911, the 911 call was made at 11:33, so Dan was on the property just shortly before 11:33 am on The police attended Dan's residence at 3:35 p.m. that day. Dan answered the door with a camera attached to his head. He was wearing a baseball cap with a video camera on the hat. He also had his phone in his hand as well as a copy of his court order.
Actually, I had the camera after I went back in to grab my bail conditions to show police.
He initially advised the officers that they could not. He advised Constable Jones that he wasn't allowed to turn off the video recorder. He then advised the police he was Victoria's most famous criminal.
Hilarious. This is how police twist what you say. I had mentioned my lawsuit and YouTube channel, and one of the cops asked me if I was Victoria's most famous criminal. He was joking, so I never actually said that. It was one of the cops that said that, and the other officer writing the report twists it to work in their favor. Why would someone with no criminal record claim to be a famous criminal? Makes zero sense.
Has a YouTube channel that has a large following. Constable Jones queried the channel. It's called Not So Silent. And Dan also stated he was going to be naming all the attending officers in a civil suit against the city of Victoria. So those are the circumstances of the offense, Your Honor. Of course, Your Honor will probably recall that this happened on August. That was initially the second date of the trial. Dan appeared in court at essentially 11 o'clock to get a new date fixed.
Dan appeared in court at 11 a.m. to get a new date fixed. Hey, that contradicts what Lorne T. Phipps fabricated when he intentionally misled the bail hearing judge about a story that I knew the trial was continuing the following day. But because this judge was part of that, Mr. Cheeseman can't use Lorne T. Phipps' fabricated story because Judge Rogers may clue in on what's really going on here.
So essentially he went right from the courthouse to Mr. Pooh's residence and was filming Mr. Pooh's wife and children.
No, I went home. The building where Mr. Pooh used to live in was a half a block away from where I live. Film Mr. Pooh's wife and children. Oh, God, here we go again. Also, do you remember when Mr. Phipps told the bail hearing judge in Part 4 that I stormed out of the courtroom? Well, why isn't that being brought up here? Why is that being left out now?
There is no criminal record to allege, Your Honor. So for that reason alone, the Crown's going to suggest, and, of course, his early guilty plea. The Crown's going to suggest that a conditional discharge could be appropriate in this case because there is no record. Dan may have some explanation for being at the property.
Yeah, I sure do. My explanation is supported by the court recordings and transcripts and contradicts the lies fabricated and brought before judges by Paul Jeffrey Cheeseman, Melissa R. Murray, and Lorne T. Phipps.
I'm going to suggest that 18 months probation to attach to the conditional discharge would be appropriate. And I've got a list of terms that I'm going to suggest I'll pass up to Your Honor. I do have a copy for Madam Clerk if Your Honor decides to impose these terms, but essentially, you honor the mandatory terms, the first 3 terms. I'd ask that there be a reporting term, Your Honor, but I would suggest that the reporting should only be for the purpose of completing counseling and that any reporting could be done by telephone.
Counseling? What do I need counseling for?
I don't think it's necessary for Dan to have to sign into the probation office once a week or every 2 weeks. As long as he's contacting probation and doing counseling that may be ordered, I think that would be sufficient. I'd ask that there be no communication, directly or indirectly, with Mr. Pooh or any members of his family. I'd ask that there be a term that he not be within 50 meters of Ding Ding O Ding Uphill Avenue, which, Victoria, BC, or any other place which he knows to be the residence, school, or workplace of Mr. Pooh or any members of his family except while on a highway in a moving motor vehicle.
Oh, so now I can't go to Ding Ding O Ding Uphill Avenue. Yes, clearly that's where Mr. Pooh lives.
So obviously Mr. Pooh and Dan live in close proximity to each other. The Ding Ding O Ding Uphill Ave is the building on southbound and uphill. So that way, he can't walk down that street, but if he is driving, he can just go to work or do what he has to. He doesn't have to be in front of the building. I'd ask that there be a term he not possess any weapon as defined in Section 2 of the Criminal Code. Of course, there's no weapons involved in the breach, but the breach attached to an assault charge.
An assault charge which I was found not guilty of.
I'd ask there be a counseling term, including anger management.
A counseling term with anger management. So by taking a picture of a building, the prosecutors insist I take anger management counseling. Brilliant.
And the last term I am going to ask for, Your Honor, is a bit different. So in addition to Dan recording Miss Pooh and the children today, and according to the police officers when they showed up to arrest him, the YouTube channel that he has, Dan videotapes many members of the Victoria Police Department. He videotaped Constable Haran his bitch for this trial. When he served him with a subpoena, he videotaped him. Apparently, according to the police, Dan is often outside the Victoria Police Department just filming officers coming and going from the building.
Ooh, congratulations, Mr. Cheeseman. You just fabricated that all on your own, because that's never happened. There is not one police officer that can tell you that I have ever shown up, even once, never mind often, even once to the Victoria Police Department to film police officers coming and going. And there are no statements written by police about me ever doing this. Sure, I've gone there lots to film, serving papers or picking up, dropping off forms, but that's very, very, very different than this lie that Paul Jeffrey Cheeseman is intentionally fabricating in order to mislead this judge. See how Mr. Cheeseman plays games with my life?
And while Dan was reporting on bail for the substantive offense, the assault, he was initially arriving at the bail supervisor's office and filming there. They had to tell him to stop it. He couldn't do that. He continued to do it.
Okay, now that is all true.
So since the probation order obviously is for the offender's rehabilitation, I would suggest that a term that bars him from filming people, from recording people in any way without their consent.
How can you bar someone from recording without their consent if it's not illegal or even harmful? You know why? Because they don't want me recording them and making YouTube series exposing what they did. And this would also mean that I can't record the police. Guess how well that would work out for me?
Would be important and would help Dan to rehabilitate and not get into trouble again.
So yes, Dan the camera terrorist needs to be rehabilitated. Make him go to camera rehab therapy or Cameraholics Anonymous. Hello, my name is Dan, and I admit I have a problem. Yes, thank you. I haven't focused a lens in almost a month, and I feel like a whole new person. Do you believe what you're hearing?
I'm not sure why he got involved in the assault in the first place, which he's now been acquitted of.
Well, there was no assault in the first place. Maybe if you did your job, or at least cared about doing your job correctly, this never would have been brought before the courts. But I know you guys needed an easy win, because that's what the justice system is all about. It's not about justice, it's about winning.
He was on bail for that. Then he goes and breaches a bail order. So I would suggest in all the circumstances of Dan's life at this point, a term such as number 9, that he not make any recording of any person without their consent, would be appropriate.
All right. Thank you, Mr. Watt.
Yes, thank you, Your Honor. Dan comes before you today at the age of, as you've heard, he has no prior criminal history. As you've heard in the trial, he resides at, and he's lived there for almost 10 years, and he resides there with Mrs. Silent. Dan has graduated from high school. He is currently employed. He is an individual that comes before you with no addiction issues and no mental health issues.
Translation: Dan doesn't qualify for a free lawyer through legal aid because he contributes too much tax.
With respect to the proposed disposition, we take issue with a few things. One thing we don't take issue with is that Dan should get a conditional discharge. In my respectful submission, it's obviously within his best interests not to have a criminal history, and certainly the facts of this breach, and that's what we're dealing with. It would not be contrary to the public interest in order to impose one. What we ask, Your Honor, is something a little less than 18 months, that being, in approximately a year. We have no issue with respect to the no contact or communication. We have some concerns with respect to the 50 meter of ding-ding-o-ding uphill avenue just given how close they are to each other.
Yeah, and we're a little less than 50 meters, so...
Both individuals seem to live in close proximity to each other, and we certainly don't want to be setting Dan up for a breach.
I can't believe he said that. We don't want to be setting up Dan for a breach. Yeah, don't do that.
We are dealing with a breach, and my friend is seeking a counseling condition, and also seeking that he cannot record anybody.
Now listen to this. Mr. Watt is literally warning Judge Rogers that what she might be about to do is unlawful.
I think we need to be very careful. Obviously, Your Honor is aware of all of the circumstances that we before you in the trial, but that is not what he has entered a guilty plea today. We are dealing specifically with a breach, and he has admitted to the essential of that breach. I can tell Your Honor that there were some issues, and, as you will recall from the trial, given what Mr. Pooh was saying in terms of where he was residing at the time.
And now Mr. Watt is putting some pressure on Judge Rogers, calling her on this. So what is Judge Rogers going to do?
My instructions are certainly he was there in order to, facilitate his defense in his trial, not in a way to intimidate or threaten in any manner. My friend hasn't alleged that, but that's a significant factor to take into account. But
You're going to have to explain that more to me because I have to say it sounds very intimidating. If was encountered, my spouse was in the midst of a trial alleging assault and the accused showed up at my residence filming me, I'd be terrified.
Judge Rogers, you're going to have to explain that to me, because if Crown prosecutors were holding me in prison and forcing me to plead guilty to an offense that I could not have committed on the record, if that happened to me, I'd be terrified.
Yes.
So that's...
No.
I'm having a bit of a problem with...
Yes.
That. So...
And I'm also having a problem with that.
No words were spoken. And, as you'll recall from the evidence of the trial, there was that whole issue with respect to whether or not Mr. Pooh actually still resided at that address.
Yeah. Anyone remember that whole issue?
And we're not putting forward in any manner to negate the essential elements of the offense. If anything, Dan is willfully blind to his conditions. But it's, in terms, as you'll recall from his cross-examination, there was an extensive amount of questioning with respect to, where he was. How he got there.
I recall all of that.
If you recall all of that, then how the hell are we here?
But why film his wife and children for what purpose other than to intimidate them or Mr. Pooh?
Never happened.
Yes. Well, my instructions, Your Honor, with respect to the location, and the building, and the residence, where Mr. Pooh essentially was saying that he wasn't living there anymore, and working to further his defense in that respect. We can't lose sight of the fact, either that Dan, Your Honor, has been on conditions of, no contact with Mr. Pooh since December 2015, and this is the first issue that has come up, and it's certainly something that came up after he had finished his testimony. So it's, in terms of, I guess, concern, or intimidation, or furthering that, Mr. Pooh, my understanding is, had finished, and his evidence was finished, so we have to consider up to that point in time that we've had no problems.
Wow, this is exactly what I've been saying all along.
He is entering a guilty plea at a very early date.
Yeah, I kind of have to, don't I?
And the conditions. Your Honor is aware of the criteria, and the connection that conditions have to have to a probation order, and they need to be either connected to Dan's rehabilitation, or they need to be connected in terms of the protection of society, and in my submission, if they're not connected, or there isn't a nexus between those two issues, then they're punitive, and if they're solely punitive in nature, then as Your Honor is aware, they're unlawful.
Boom! Warning to the judge. What you may be about to do is punitive and unlawful.
And does have a YouTube channel that he does put things on the YouTube site. There are issues, and you've got a little bit of this from his evidence. There have been prior issues with respect to the police, and certainly, and it's arguable, individuals, filming interactions with the police or police filming interactions with individuals is, protection, or protecting both, and ensuring that there is complete transparency in the entire process of any type of police involvement with any citizens. There's nothing to indicate before you that there's this prior history with respect to filming individuals, like unsuspected individuals. There is information with respect to him filming the police and ensuring that they're upholding the law as they're supposed to be.
Imagine that.
So a complete blanket on not being able to record or have access to those devices, I think is not really connected to the order that we see, as well as counseling, given that we're dealing with a breach, and I would submit I'm not sure I see the connection with respect to that. So when you take into account those factors as guilty plea, that my friend is agreeable that a conditional discharge can be appropriate, we're just in disagreement with respect to the length and the circumstances.
And the circumstances! Oh yeah, we disagree with the circumstances!
I submit that's the appropriate disposition.
How long has he been in custody?
2 weeks today.
He has been in custody since of August.
Since the date of the offense?
Yes.
And solely on this, I gather?
His bail was revoked on the assault.
Yes.
Yes.
On the other matter?
Yes.
But as a result of this?
Yes.
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 And I can tell Your Honor as well that's had a significant impact on him. He is not someone that's had any interaction with the criminal justice system, and he's been in for a period of time, so I think that's certainly something that you can consider in determining, the appropriate disposition.
Thank you.
And if I can just add, Your Honor, that is one of the reasons why Crown is seeking.
Yes.
A conditional discharge is appropriate because there has been some time served on this, as it were.
Yes, Your Honor. Let's let Dan off easy. After all, we just made him spend 2 weeks in prison with no criminal record for taking a picture of a building.
Absent that, I would suggest that due to the nature of it, a discharge would not be appropriate, but given the entire circumstances, that's why.
Yes.
I'm making that submission.
All right. Thank you.
Thank you.
And I'm released that day, went back to work, and my life was saved by pleading guilty to an offense that I could not have committed. And it's all on the record. Judge Rogers agrees to a conditional discharge. And in Judge Rogers' sentencing, I was given 18 months probation with the option to have the probation revoked after 9 months if I complete a violence prevention anger management counseling. Other conditions include that I not attend any place that I know to be the residence of Mr. Pooh. Haha, what about any place that he lived? Just kidding. Condition 7, I shall not be on the property of or the sidewalk immediately adjacent to the property of Ding Ding Oh Ding Uphill Avenue. It's beginning to sound like whether he lives anywhere or not. If I go somewhere, like anywhere, I could be across town and I'll be arrested. Oh, he lives here too? Oh, wow, what are the chances? Condition 9. Condition 9 goes on about anger management counseling, so this is a mandatory part of my conditions. This, along with the next part, Condition 10, is what my lawyer, Mr. Watt, warned Judge Rogers about when he said that if the probation conditions were punitive, then they're unlawful. With that in mind, let's get to Condition 10. I shall not make any recordings of a person in any way, including audio, video, or digital recording, without that person's express consent, except you may make recordings if you are having direct interactions with the police, or incidental to the recording of traffic events in your dash camera. So because I was forced to plead guilty and had to abide by these unlawful conditions, I completed violence prevention counseling within 9 months. I made an application to a judge to have the probation revoked after 9 months. I appeared in person for a hearing, and my application was granted. Around this time, I was actively going through the DARS recordings and ordering transcripts. And in July 2017, I filled out the forms and sworn in paperwork before a Justice of the Peace to have Mr. Pooh, Melissa R. Murray, Paul Jeffrey Cheeseman, and Lauren T. Phibbs criminally charged. I'll conclude Part 6 here. So, what happens when you seek accountability from the justice system? That's all coming up in Part 7. But for now, please leave a comment below about how you think Paul Jeffrey Cheeseman handled this case. And what do you think about Paul Jeffrey Cheeseman having a local law office here called Cheeseman Law, where he runs a private practice where he takes on immigration and criminal defense cases? So what kind of service would you get from a criminal defense lawyer that fabricates evidence, obstructs justice, and criminally harasses justice participants so that they stay in prison and are forced to plead guilty to a crime that they could not have committed? Would you hire or recommend a criminal defense lawyer that would go to that level of dishonesty? Technically, Mr. Cheeseman was the one who got the ball rolling when he told Mr. Kuzma in Part 5 that he had a different recollection than my version of the events, which was that Mr. Pooh stating several times that he no longer lived there. That's really where all this began. And if Paul Cheeseman would have just been honest about it from the beginning and admit that Mr. Pooh did in fact state several times that he no longer lived there, then I likely would not have been charged, held in prison for 2 weeks without a criminal record, and forced to plead guilty to an offense that I could not have committed. Clearly, Paul Jeffrey Cheeseman is a dishonest lawyer, and Mr. Cheeseman will lie about anything in order to get a win for his buddies, the Crown Prosecutors. Shame on you, Mr. Cheeseman. What an embarrassment to our justice system. And also, how about Judge Carmen Rogers? Judge Rogers is actually the regional administrative judge for Vancouver Island. Is this what you would expect from a regional administrative judge? I cannot wait to read your comments. Thanks for watching.